Hello and welcome to this session in which we'll discuss the concept of agency relationship. Agency is a legal concept where one person or one entity, could be a company, known as the principal, allows another, give the permission of another person or another entity who's known as the agent to act on their behalf. The easiest classic example to illustrate is a family hiring an agent, a real estate agent, to either sell, let's assume that's their home, they want to sell this home. Therefore, they will hire the agent, and the family here, the couple, is the principal, and they would hire the agent to do something on their behalf. And in this situation, we're going to say sell their home. Now, there's the principal, there's the agent, and we sell the home to a third party. We don't know who that third party is, it's the buyer. But this is what the relationship is. For an agency relationship to be established, to be formed, we have to have certain criteria, and we're going to start by discussing those criteria. First, the principal. Who's the principal? The family here. They have to have capacity and they have to give consent. The principal must legally capable of entering into a contract, meaning that they are not minor or legally incompetent. Also, both principal and agent must have to agree to this relationship. There's a mutual assent between the two. I'm hiring you and you agree to be my agent. Before we proceed any further, I have a public announcement about my company, farhatlectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses, broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
Do we need a written agreement to have a valid relationship between principal and the agent? Generally, we don't need a written agreement. However, there are some exceptions here. What are the exceptions? And those exceptions are related to something that we covered earlier about the statutes of fraud, which are if the agent is to buy or sell land on behalf of the principal, many states would require a written agreement. Now, bear in mind, contract to find a buyer or a seller, like if you're a real estate broker, or to build a home, are considered service contract, no need for written agreement. Also, if the agency agreement cannot be completed within 1 year, and we saw this as well in the statutes of... Also, if the agency agreement cannot be completed within 1 year, this must be evidence in writing, and we saw this earlier. So, under those two circumstances, we have to have a written agreement. So that's the second component. Is written agreement required? In some circumstances. Otherwise, not needed. Capacity of the agent and consideration. Capacity of the agent. Interestingly, well, how about capacity of the agent? Well, believe it or not, although the principal must be competent, the agent does not have to be. What does that mean? It means you can hire a minor or someone who is mentally incompetent to act on your behalf. If you want to do that, well, you need to check your mental health yourself, but that's a different story. But you can do it. That will form it. Otherwise, if the principal is minor, you can't have it, or if they're mentally incompetent. But an agent can be a minor or mentally incompetent. Do you need a consideration to have a valid relationship? No. Unlike many contracts, an agency relationship does not have to have consideration, something of value, exchange between the two parties. Think about a parent-kids relationship. Well, for example, you can represent your son, your son can represent you, there will be no consideration. So you can have an agency relationship, no consideration is needed. Let's take a look at a comprehensive example to illustrate everything that we talked about. Sarah, a competent adult, good, owns a large plot of land. She wants to sell the land, but does not have time to handle the process. So she's a competent adult, she can be the principal, she can hire an agent. She decided to appoint Alex to act on her behalf. Alex is the agent. What type of a relationship is this? Well, it's an principal-agent relationship, and Alex will have to find the buyer and handle the sale. Does it have to be in writing? And the answer is yes. Why? Because it's the sale of land. Now, Alex is 17 years old, a minor. Can he act as an agent on behalf of Sarah? And the answer is yes, because only the principal need to be competent. Now, since the transaction involved the selling of land, they will have to have a written agreement as required by law in their state. They agree that Alex would receive a commission from the sale as his payment, but it's important to note that even there was no such payment, the agency relationship would still be valid because no consideration is needed to form an agency relationship. Let's talk about something called the power of attorney. So what's that power of attorney, or POA? It's a legal document that grant an agent the authority to act on behalf of the principal. In the context of agency, the term attorney in fact refer to the agent who doesn't have to be a lawyer. For example, I am attorney in fact for my brother. It's true. My brother, he has his own consulting company. He travels overseas all the time. So I do handle his finances. When I go to the bank, I can handle his finances because I am the attorney in fact. I'm not an attorney at all, but I do have this power of attorney from him. This designation simply means that I have the legal power to represent my brother, the principal, in this situation. Now, typically, the principal needs to sign the power of attorney. I never signed it. The agent's signature is not required. Now, the scope of the agent authority is usually restricted to a particular transaction. And indeed, my brother only gave me the authority to act on his behalf with his bank accounts, and that's plenty. So having access to his bank account, basically having access to everything. But the POA, it says I can withdraw, wire, deposit, do whatever I have to do in his bank account. Example, John, an elderly man who wishes to manage his financial affair but is planning to travel abroad for an extended period of time, similar to my brother's situation. He decides to grant a POA to his daughter Lisa. John signs a POA document stating that Lisa can handle his financial transaction while he's away. Well, in this scenario, Lisa becomes John's attorney in fact, allowing her to pay bills, manage his bank account, and make financial decisions on his behalf. However, her authority is limited to financial matters specified in that document, in the POA document, power of attorney. She cannot make healthcare decisions for John unless specified otherwise in the document. So this example demonstrates the practical use and limitation of the POA in the agency relationship. Now let's talk about the duties of the agent. Now, as an agent, you have to have certain duties. Duties to who? To the principal. So you owe the principal several key duties. And understanding these duties help in grasping the nature of the agent-principal relationship. Let's talk about the first duty. The duty of loyalty. You have to be loyal. The agent must act exclusively in the best interests of the principal. They should avoid conflict of interest and cannot benefit at the principal's expense. It means they cannot generate profit from this relationship for themselves. They have to think of the principal as the person, the main goal. So all the profit, all the work should go toward the principal's interest, not your interest, because they hire you to work on their behalf. For example, Maria is an agent who manages contract for a company. She's an agent. She must not accept gift or bribes from contractor for favoring their bid. If she does, she breaches her duty of loyalty by prioritizing her interests over the company, because now she may not find the best bid. She's gonna give the bid to the person that's give her the most bribe. Well, she's not thinking about the interests of her company. So duty of loyalty. Another duty is duty of obedience. What does that mean? It means listen to the principal's wishes. The agent is required to follow all lawful, of course it has to be lawful, and reasonable instruction given by the principal. If they ask you to throw yourself on the top of the building, he should not do that. But anything lawful and reasonable, they should comply with those requests. For example, if Tom is a real estate agent and is instructed by his client to only look for commercial property within a certain budget, he must adhere to those specific instructions and not consider properties outside the budget or the scope. So it has to be commercial within that budget. So this is what you would look for. Also, duty of reasonable care. This duty requires the agent to perform the responsibility with the same level of care and skill that a reasonably prudent person would exercise in similar circumstances. Well, think about what is your best interest and you will act based upon that, assuming you are a prudent person, and we assume that people are prudent. For example, Linda, a financial advisor acting as an agent on behalf of her client. Well, Linda must invest in her client's money wisely and cautiously as a reasonably prudent person would do within their own investments. So you should not be, for example, buying option risky investments. You have to be prudent. That's what duty of reasonable care. Also, duty to account. The agent must keep accurate record of all transaction and money handled while acting on behalf of the principal. Simply put, don't commingle your money with that of the principal. They should not mix the principal assets, money, with their own money. For example, if Jordan, acting as an agent, collects rent from properties for a landlord, he must keep a detailed account of all collection and expenses. He cannot mix the money with his personal funds and must report all financial activities to the landlord. Why? Because you are acting on behalf of the landlord. What is a sub-agent? Remember, an agent, we have a principal, and the principal can hire an agent. Now also, this agent can hire other agents. They're called sub-agent. A sub-agent is someone appointed by an agent to assist them in carrying out the task of the principal. And this is very common in real estate. For example, I'm buying a house now. I have a real estate agent, but sometimes what happens is, if he does not have time to show up for my, when I need to look for a house, he does have another agent, that sub-agent, that can help me. So it's an agent, a sub-agent. A sub-agent, when an agent has the authorization to hire a sub-agent, the sub-agent becomes responsible for performing their duties with care toward both the agent and the principal. This means that the sub-agent is expected to adhere to the same standards of conduct and obligation as the original agent in fulfilling their responsibilities. Example, Emma, a principal, hires Adam as her real estate agent to sell her house. So we have Emma as the principal, hires Adam as the agent. However, Adam, due to his busy schedule, is authorized by Emma to hire a sub-agent. Adam's gonna hire Noah. Here Noah is the sub-agent. This is what the picture looks like, to help with some tasks. Now Noah, as a sub-agent, has the duty to act in Emma's best interests and also to fulfill his responsibilities as directed by Adam. Now if Noah is tasked with staging the house for a showing, he must do so with the level of care that's acceptable to both Emma and Adam. He must follow Adam's instruction about staging while ensuring that his action is aligned with Emma's best interest in selling the home. If Noah neglects these duties, he could be held accountable by both Adam and Emma for any resulting issues or losses. Let's take a look at this multiple choice questions from farhatlectures.com. What constitutes a breach of duty of loyalty in an agency relationship? So we have an agency relationship and there's a breach of loyalty. What is a breach of loyalty? Which example is this? The agent following all the principal's instruction. Well, is this a breach? Well, that's not at all. That's not a breach of duty. That's an easy elimination. A is out. Let's start from D. The agent keeping a detailed account for all transaction. Well, that's a good practice, but that has nothing to do with the duty of loyalty. This had to do with the duty to account. We have duty to account, and if the question was about duty to account, this will be the correct answer. But the question is about duty of loyalty. Now we're 50-50 between B and C. The agent performing their duties with reasonable care. Well, you have to perform your duties with reasonable care, but has nothing to do with loyalty. C is out. Let's look at B. The agent receiving personal benefit from a third party. Is this a breach of duty of loyalty? And the answer is yes. When you receive benefits, extra money from a third party, well, you are breaching your duty of loyalty in an agency relationship. What should you do now? You want to go to Farhat Lectures, look at additional resources, multiple choice, additional lectures that's going to help you whether you are preparing for your CPA exam or taking your business law courses. Invest in yourself. Good luck, study hard, and of course, stay safe.